August 20th, 1947, Palace of Justice, Nuremberg, Germany. The courtroom fell silent as Brigadier General Telford Taylor stood before the tribunal, holding a leather-bound ledger stamped with SS insignia. Inside this document were the names of 16 men who believed they would never face judgment. Nazi doctors who had conducted medical experiments on prisoners at Dachau, Ravensbrück and Buchenwald. Men who had signed death warrants disguised as research protocols. Men who had injected typhus into healthy prisoners to test vaccines. Who had submerged victims in ice water until their hearts stopped. Who had performed surgeries without anesthesia to study pain tolerance. They had operated with absolute authority, protected by Hitler's regime, answerable to no law except their own twisted interpretation of medical science. They were certain their crimes would die with the Reich, buried under rubble and ash, lost in the chaos of Germany's collapse. They were wrong. In the next 12 hours, American military justice would convict all 16 defendants in a single day, shattering Nazi Germany's final illusion that their doctors of death would escape accountability. The speed, precision, and finality of American justice would stun Germany and establish precedents that would reshape medical ethics forever. This was not revenge. This was not victor's justice. This was the rule of law moving with surgical precision, demonstrating that no title, no uniform, no claim of following orders could shield perpetrators from judgment. The Nazis had built their medical experiments on a foundation of dehumanization. They classified victims as subhuman, as research material, as expendable subjects in the service of racial science. American prosecutors would prove that every experiment violated not only international law, but the most fundamental principles of medicine itself. The oath to do no harm, the requirement of informed consent, the prohibition against using human beings as laboratory animals. These were not abstract philosophical concepts. They were concrete legal standards that the Nazis had systematically violated, documented in their own meticulous records. What made this conviction extraordinary was not just its speed, but its foundation. The Americans had spent months building a prosecution machine that ran on evidence, documentation, and eyewitness testimony. They had interviewed hundreds of survivors. They had recovered thousands of pages of medical records that the SS had failed to destroy. They had brought in expert witnesses from neutral countries to testify about medical ethics. They had created a legal framework that would survive scrutiny for generations. This was American justice at its most powerful, demonstrating that accountability was not optional. That documentation created permanent records that the world was watching, and that crimes against humanity had no statute of limitations. The 16 defendants sitting in the dock that morning believed they would be released. Their lawyers had argued that they were following orders, that wartime conditions justified extreme measures, that the experiments served legitimate military medical research. The prosecution had systematically demolished every defense. And now, on this August morning, the tribunal was ready to render its verdict. Germany was about to learn that American justice moved faster, struck harder, and reached farther than anything the Reich had ever imagined. The Doctors Trial, officially United States of America versus Karl Brandt et al., was the first of 12 subsequent Nuremberg trials conducted by American military tribunals after the main international military tribunal concluded. 23 defendants faced charges, but 16 would be convicted on August 20th, 1947, in a verdict that took less than 8 hours to read and process through the American military justice system. The architects of this judicial operation were American military lawyers who understood that medical war crimes required different prosecution strategies than battlefield atrocities. These were not soldiers who had violated the laws of war in the heat of combat. These were physicians who had violated every ethical principle of medicine systematically, deliberately over years, with full documentation. Telford Taylor, chief prosecutor, had assembled a team of medical experts, forensic pathologists and international law specialists to build an airtight case. The prosecution strategy was revolutionary in its simplicity. Use the Nazis' own documentation against them. German bureaucratic precision, their obsession with recording every detail, became their downfall. Every experiment had been meticulously documented. Subject numbers, dates, methods, results, photographs, all recorded in ledgers that SS officers had failed to destroy before American forces arrived. The Americans recovered over 4,000 pages of original medical records from Dachau alone. These documents proved beyond doubt that experiments were conducted without consent, resulted in death or permanent injury, and served no legitimate medical purpose. The prosecution presented evidence systematically, building case files that read like corporate reports, except they documented murder. Documents establishing orders from Berlin, photographs of victims before, during, and after experiments, medical records showing cause of death written in clinical German, testimony from survivors who identified their torturers by name, by voice, by the specific procedures they had performed. Each piece interlocked with devastating precision. What made the American prosecution unprecedented was its speed and efficiency. Unlike the main Nuremberg trial, which lasted 10 months, the Doctors Trial moved decisively through its evidence phase. The Americans had learned from the main trial. They streamlined procedures. They used American filing systems to catalog thousands of documents. They employed teams of translators, working in shifts to process German medical records overnight. They brought in expert witnesses who could testify about specific procedures and their medical legitimacy. They cross-referenced survivor testimony with German documents to create unbreakable chains of evidence. The defendants had expected a different kind of trial. They had expected delays, procedural arguments, opportunities to blame dead superiors. Instead, they faced an American legal machine that operated with assembly line efficiency. Every morning, new evidence. Every afternoon, new witnesses. Every evening, transcripts prepared for the next day. The Americans demonstrated that justice delayed was justice denied, and they had no intention of delaying. The Nazi doctors had operated in a world where medical ethics were subordinated to racial ideology. They had convinced themselves that their experiments served a higher purpose, that individual suffering was justified by collective benefit, that informed consent was unnecessary when dealing with inferior races. The American prosecution systematically dismantled these justifications. They brought in medical ethicists from neutral countries who testified that no legitimate medical research required torture, that consent was foundational to ethical medicine, that the experiments served no valid scientific purpose. They presented evidence that similar research questions had been answered through ethical means in other countries. They demonstrated that the Nazi experiments were not science, but sadism dressed in medical terminology. The 16 defendants sitting in the dock represented different aspects of Nazi medical crimes. Karl Brandt, Hitler's personal physician, who had authorized the euthanasia program. Wolfram Sievers, who had overseen experiments at multiple camps. Kurt Blom, who had directed biological warfare research. Waldemar Hoven, camp doctor at Buchenwald, who had killed prisoners with phenol injections. Each had believed their position protected them. Each had underestimated American determination to achieve accountability. The prosecution had spent months preparing for this moment, and now they were ready to deliver justice with unprecedented speed. The prosecution phase of the Doctors Trial revealed something the Nazi defendants had not anticipated: American organizational capacity applied to justice. While Nazi Germany had excelled at bureaucratic documentation of crimes, the United States had mastered the systematic presentation of that documentation in a courtroom. The difference was devastating. On the morning of June 2, 1947, Prosecution Exhibit 347 was introduced into evidence. It was a photograph taken at Dachau in February 1942, showing a prisoner submerged in a tank of ice water, electrodes attached to his body. German doctors in white coats standing nearby with clipboards, recording his vital signs as hypothermia set in. The photograph had been taken by the Germans themselves, part of their research documentation. The Americans had recovered it, catalogued it, verified its authenticity through 3 independent sources, and now presented it to the tribunal with clinical precision. This was not an isolated incident. The prosecution had recovered hundreds of such photographs, thousands of pages of experimental protocols, and tens of thousands of individual victim records. The scale of documentation was overwhelming. Nazi doctors had photographed their experiments. They had filmed surgical procedures. They had maintained detailed logs of subject reactions, survival times, and causes of death. They had written research papers intended for publication in German medical journals. They had created a complete archive of their crimes, never imagining it would be used against them in an American court. The American prosecution team had established a document processing system that would become a model for future war crimes trials. Upon capturing German facilities, American military intelligence units had immediately secured medical records. These were photographed, translated, and indexed using American library science methods. Each document was assigned a unique identifier. Cross-references were created linking documents to specific defendants, specific victims, and specific charges. By the time the trial began, prosecutors could retrieve any piece of evidence within minutes. This organizational superiority extended to witness preparation. The Americans had located over 200 survivors of Nazi medical experiments scattered across Europe. Teams of investigators interviewed each survivor, documented their testimony, corroborated their accounts with German records, and identified which defendants they could personally identify. Witnesses were brought to Nuremberg in groups, housed in secure facilities, given medical examinations to document lasting injuries, and prepared for cross-examination. When survivor testimony was presented, it was supported by documentary evidence, photographs, and expert medical analysis. The Nazi defense strategy collapsed under this evidence avalanche. Defense attorneys had planned to argue that experiments were justified by military necessity, that subjects were volunteers, that deaths were unintended consequences of legitimate research. The documentary evidence demolished these claims. German records showed prisoners were forced into experiments. Death rates were recorded with indifference. Research protocols had no legitimate medical purpose. Multiple experiments were conducted purely to test human endurance limits before death. The prosecution brought in medical experts from neutral countries to evaluate Nazi research protocols. Swiss physicians testified that the hypothermia experiments violated every principle of medical ethics and produced no useful scientific data because variables were not controlled. Swedish doctors explained that the high-altitude experiments caused predictable deaths and revealed nothing that could not have been learned through non-lethal methods. American military physicians testified that battlefield treatments developed through Nazi experiments had been independently developed through ethical research in Allied countries, proving the Nazi crimes were unnecessary. By July 1947, the evidence phase was complete. The prosecution had presented testimony from 85 witnesses and introduced over 1,500 documents into evidence. Every defendant had been linked to specific crimes through multiple forms of evidence. The tribunal had heard testimony in German, English, French, and Polish, all translated in real time by American military interpreters. The entire proceeding had been recorded by stenographers working in shifts, creating a permanent record that would eventually fill over 11,000 pages of transcript. The Nazi defendants had believed their crimes were too complex for outsiders to understand, too embedded in German medical culture for foreign courts to judge. They had underestimated American determination to understand, document, and prosecute every aspect of their criminal medical program. The Americans had not merely collected evidence, they had built a prosecution machine that ran on facts, operated with industrial efficiency, and produced inescapable conclusions. The tribunal was ready to deliberate, and the defendants were about to discover that American justice moved with the same overwhelming force that had crushed the Wehrmacht. While the world focused on the dramatic courtroom testimony, the real American advantage operated behind the scenes in a system the Germans had never imagined. In a converted school building 3 blocks from the Palace of Justice, American military personnel ran what was essentially a legal factory. This was where American institutional capacity revealed itself most dramatically, and where Nazi assumptions about legal proceedings were shattered. The Document Processing Center employed over 100 staff members working 3 shifts around the clock. German documents arrived in canvas bags from archives across occupied Germany. Each bag was logged, contents inventoried, documents photographed, and copies distributed to translators, prosecutors, and defense attorneys simultaneously. This parallel processing eliminated delays. While prosecutors were presenting evidence from morning raids, documents from afternoon raids were already being translated and catalogued for next week's proceedings. The Germans had never experienced legal proceedings that moved at industrial speed. German courts operated on continental legal traditions, where cases could stretch for years, where document discovery occurred slowly, where procedural delays were routine. The Americans brought assembly line efficiency to justice. They had learned from their industrial mobilization during the war that any process could be systematized, accelerated, and scaled. They applied these principles to legal proceedings with devastating effect. Translation was a particular American advantage. The prosecution had recruited over 40 translators, many of them German-speaking American Jews who had fled Nazi Germany in the 1930s. These translators understood medical terminology, legal language, and the euphemisms the Nazis used to disguise crimes. When a German document referred to special treatment, American translators knew it meant execution. When experiment protocols mentioned subjects, translators knew these were prisoners who had not consented. This linguistic expertise prevented Nazi attempts to hide behind technical jargon. The Americans also revolutionized how witness testimony was handled. In traditional European courts, witnesses testified once their statements were recorded by hand, and cross-examination was limited. The Americans brought stenographers who could record testimony at 150 words per minute, creating verbatim transcripts available within hours. They used this system to devastating effect. When defense attorneys claimed a witness had misstated facts, prosecutors produced exact transcripts proving otherwise. When defendants claimed they had been misquoted, stenographic records proved their actual words. This documentation made lying impossible and evasion futile. Medical forensics was another American innovation at Nuremberg. The prosecution brought in American military pathologists who had examined concentration camp victims immediately after liberation. These doctors had photographed injuries, documented cause of death, and preserved tissue samples. When Nazi doctors claimed their experiments had not caused deaths, American pathologists presented autopsy evidence, proving otherwise. When defendants claimed prisoners died of disease, forensic analysis showed evidence of deliberate killing. The scientific rigor of American medicine confronted the pseudoscience of Nazi racial research, and the contrast was stark. Communications technology gave the Americans yet another advantage. The prosecution maintained direct telephone and teletype connections to military archives in Berlin, Munich, and Vienna. When defense attorneys introduced new claims, prosecutors could request supporting or contradicting documents from German archives and receive them within 48 hours. This real-time access to evidence prevented defense attorneys from making unchallenged claims about what German records actually said. The Nazis had designed their medical experiments to leave minimal evidence beyond what they controlled. They had not anticipated that American forces would capture intact archives, that American intelligence would systematically preserve evidence, that American prosecutors would employ industrial methods to process documentation. The Nazi assumption that complexity would protect them, that the sheer volume of crimes would overwhelm investigators, proved catastrophically wrong. American prosecutors had not become overwhelmed. They had become more efficient. The tribunal deliberations began in early August 1947. American legal staff had prepared detailed summaries of evidence for each defendant, cross-indexed by charge, by victim, and by documentary proof. These summaries ran to hundreds of pages, but were organized so clearly that judges could locate any piece of evidence within seconds. The Americans had created what modern lawyers would call a litigation database, except they had built it using index cards, filing cabinets, and telephone connections. The technology was mid-20th century, but the methodology was revolutionary. By August 19th, the tribunal had reached its verdicts. The deliberation had taken less than 3 weeks because the evidence was so thoroughly organized that judges could review entire cases in hours rather than months. On the morning of August 20th, the verdicts would be read, and 16 Nazi doctors would learn that American justice operated at a speed they had never imagined possible. The American advantage was not rhetorical brilliance or legal philosophy. It was systems, organization, and the industrial application of resources to legal proceedings. The Americans had brought to Nuremberg the same institutional capacity that had produced 50,000 aircraft per year, that had landed armies on 2 continents simultaneously, that had built atomic weapons in secret facilities. That capacity applied to justice was unstoppable. August 20th, 1947, 9:00 a.m. The Palace of Justice courtroom filled with spectators, journalists, military observers, and survivors who had traveled from across Europe to witness this moment. The tribunal judges entered, led by Judge Walter Beals of the United States. The 16 defendants sat in 2 rows, some defiant, others visibly nervous, all certain they would mount successful appeals even if convicted. They had no idea they were about to experience American justice at maximum velocity. Judge Beals began reading the verdict at exactly 9:07 a.m. The tribunal had prepared a comprehensive judgment document running over 200 pages, but the oral verdict delivery was structured for maximum efficiency. Each defendant would hear their individual verdict, the specific charges proven, and the sentence imposed. No delays, no procedural interruptions. Justice delivered with the precision of an assembly line. Karl Brandt, Hitler's personal physician, was first. Guilty on counts 1, 2, and 3. Conspiracy to commit war crimes, crimes against humanity. The evidence against him was overwhelming. Brandt had personally authorized the T4 euthanasia program that killed over 70,000 disabled Germans before the war even began. He had approved high-altitude experiments at Dachau that killed dozens of prisoners. He had coordinated medical experiments across multiple concentration camps. His defense that he was following Hitler's orders was rejected. Medical ethics transcended political commands. Sentenced death by hanging. Brandt's face went white. He had expected years of appeals, perhaps eventual release. Instead, he had just been condemned to death in under 5 minutes of judicial pronouncement. The American tribunal was not interested in extended deliberation. The evidence had been clear, the verdict was final, and the sentence would be carried out. Wolfram Sievers was next. As director of the Nuremberg Institute, he had overseen some of the most horrific experiments conducted in Nazi camps. Skeleton collections created by murdering Jewish prisoners, typhus experiments that killed hundreds, poison bullet experiments designed to maximize suffering. Guilty on all counts. Sentenced death by hanging. The verdicts continued with mechanical efficiency. Waldemar Hoven, camp doctor at Buchenwald, who had killed prisoners with phenol injections for minor infractions, who had conducted typhus experiments that served no medical purpose, who had eliminated witnesses to SS crimes through lethal injection. Guilty, death by hanging. Joachim Murugowski, who had directed hygiene experiments that involved deliberately infecting prisoners with diseases. Guilty, death by hanging. The death sentences accumulated with devastating speed. By 10:30 a.m., 7 defendants had been sentenced to death. The Nazi doctors had believed their medical credentials would protect them, that their claim of following orders would provide defense, that international sympathy for medical research would create leniency. They had been catastrophically wrong. The American tribunal had established that medical training created greater responsibility, not immunity. That following orders was not a defense for crimes against humanity. That pseudo-scientific justifications for torture were legally worthless. The remaining verdicts came swiftly. 5 defendants received life imprisonment. Victor Brack, who had helped organize the T4 program and later proposed using X-rays to sterilize millions of people. Rudolf Brandt, who had coordinated experiments and served as Himmler's liaison to camp doctors. Siegfried Handloser, who as chief medical officer of the Wehrmacht had known about and failed to stop criminal experiments. Each guilty verdict reinforced the same principle. Knowledge of crimes created obligation to prevent them, and failure to act made one complicit. 4 defendants received prison terms ranging from 10 to 20 years. These were doctors who had participated in specific experiments, but had not initiated or coordinated broader criminal programs. Their sentences reflected degrees of culpability, but even the shortest sentence carried a message. Participation in medical crimes, even under orders, even in limited capacity, would result in punishment. By noon, all 16 convictions had been delivered. The entire verdict reading had taken less than 3 hours. The American tribunal had processed 16 complex cases, evaluated thousands of pieces of evidence, considered hundreds of hours of testimony, and delivered individualized sentences in the time it would take a German court to complete opening arguments. The Nazis had always prided themselves on efficiency. American justice had just demonstrated what true efficiency looked like. The convicted doctors sat in stunned silence. They had expected procedural delays, appeal opportunities, perhaps years before final judgment. Instead, they had been tried, convicted, and sentenced with a speed that seemed impossible under any legal system they understood. This was the American advantage made visible, not just superior evidence or better organization, but the will to move decisively from proof to verdict to sentence without hesitation. The courtroom observers sat equally stunned. Journalists scrambled to file stories. Military observers took notes on procedures they would replicate in future trials. Survivors wept, some in relief, some in rage that any sentence seemed inadequate for the suffering inflicted, but all recognized they had witnessed something unprecedented. A legal proceeding that combined meticulous evidence collection with rapid verdict delivery. Justice that was both thorough and swift. Outside the Palace of Justice, news of the verdicts spread through Nuremberg within minutes. American military radio broadcast the results across occupied Germany. Newspapers prepared special editions. The message was clear and deliberate. Nazi war criminals would be identified, tried, and punished, with a speed and certainty that no delay tactic could prevent. This was not revenge. This was not victor's justice imposing arbitrary punishment. This was law operating at full capacity, demonstrating that documentation created accountability, that criminal medicine would be treated as crime, and that American legal systems could process complex cases with the same efficiency that had built Liberty ships and B-17 bombers. The 16 convictions delivered on August 20, 1947, represented more than individual punishment. They represented the establishment of precedents that would reshape international law, medical ethics, and accountability for human rights violations. The Nuremberg Code, derived from this trial, would become the foundation of modern medical research ethics. The legal principles established would influence war crimes tribunals for generations, and the speed of American justice would become a template for accountability worldwide. The verdicts hit Germany like a shockwave. Across the occupied zones, Germans who had convinced themselves that Nazi crimes were exaggerated, that Allied accusations were propaganda, that their doctors had acted appropriately under wartime conditions, now confronted undeniable reality. American justice had not merely alleged crimes. It had proven them with German documentation, convicted perpetrators with their own records, and imposed sentences that would be carried out swiftly and certainly. The German reaction revealed a population struggling to comprehend the moral and legal implications of what their regime had done. In Munich, former SS officer Hans Münch read the verdict summary in an American military newspaper and immediately understood the significance. Münch had worked at Auschwitz, but had refused to participate in selections or experiments. He had survived the war by testifying against his former colleagues. Now reading about the Nuremberg convictions, he realized the depth of criminality he had witnessed. "We thought the experiments were justified," he later told American interrogators. "We believed the research served the fatherland. We never imagined we would be held accountable under international law. We never thought American courts would have the evidence to prove what we had done." Münch's testimony revealed the Nazi mindset perfectly. They had convinced themselves that national service justified individual crimes, that wartime conditions suspended ethical obligations, that destroyed Germany would lack the capacity to prosecute, and that victors would move on rather than document atrocities. They had been wrong on every count. German medical institutions struggled to respond. The German Medical Association, attempting to rebuild credibility under Allied occupation, issued a statement acknowledging that some doctors had violated medical ethics, but suggesting these were isolated incidents during wartime chaos. The American occupation authorities immediately rejected this narrative. They released statistics showing the scope of medical crimes. Over 7,000 doctors had joined the Nazi Party. Hundreds had participated directly in experiments or euthanasia programs. Thousands more had known about criminal medicine and done nothing to stop it. This was not isolated incidents. This was systematic corruption of an entire profession. German newspapers, now operating under Allied press regulations, published extensive coverage of the Nuremberg verdicts. For the first time, ordinary Germans read detailed descriptions of experiments conducted in their names. Hypothermia experiments at Dachau, bone transplant experiments at Ravensbrück, typhus experiments at Buchenwald, each experiment described in clinical detail drawn from German medical records that doctors had created themselves. The documentation was irrefutable because it came from Nazi sources. Germans could not dismiss it as Allied propaganda when it was written in German medical terminology by German doctors in official SS documents. The speed of the convictions particularly shocked German legal observers. Under German legal traditions, cases of this complexity would require years of investigation, procedural reviews, and appeals. The Americans had completed the entire process in months. They had processed thousands of documents, interviewed hundreds of witnesses, and delivered final verdicts while German courts were still struggling to resume basic operations under occupation. This demonstrated not just superior resources, but fundamentally different approaches to justice. German law emphasized procedural thoroughness. American law emphasized efficient resolution. When American procedures were combined with American resources, the result was devastating effectiveness. In Heidelberg, German medical students gathered to discuss the implications. These were young doctors who had trained during the Nazi era, who had been taught that race determined medical treatment priorities, who had absorbed the idea that some lives had greater value than others. Now they confronted American and British medical educators, who explained that the Nuremberg convictions had established new international standards. Medical research required informed consent. Experiments on human subjects required ethical review. Doctors who violated these standards would face criminal prosecution regardless of national laws or military orders. The students struggled to understand how rapidly their profession had been redefined. In Frankfurt, a German lawyer who had practiced throughout the Nazi era tried to explain to American occupation officials why the Nuremberg process seemed alien to German legal culture. "You must understand," he argued, "German law respects proper procedures. Your courts moved too quickly. You did not allow sufficient time for defense preparation. You imposed standards that did not exist when these acts occurred." The American judge hearing this complaint responded with cold precision. The Geneva Conventions existed. The Hague Conventions existed. Basic medical ethics existed. Your doctors violated all of them knowingly and systematically. Our courts documented these violations using records your doctors created. The speed of our proceedings reflects the clarity of evidence, not inadequate procedure. Germany will learn to operate under international law, whether you consider it alien or not. This exchange captured the fundamental disconnect. Germans expected legal proceedings that accommodated their traditions, their pace, their procedural expectations. Americans imposed a legal framework based on international standards, documentary evidence, and efficient resolution. The occupation would continue until Germany accepted that its legal culture had enabled criminality and needed fundamental reform. Perhaps the most telling German reaction came from the defendants' families. Wives and children of convicted Nazi doctors protested that their husbands and fathers had been condemned too quickly, without adequate appeals, without consideration of mitigating circumstances. They presented petitions to American military governors requesting clemency, sentence reductions, or new trials. These petitions revealed assumptions that were jarring to American authorities. The families argued that the doctors had believed they were serving Germany loyally, that wartime circumstances justified extreme measures, that soldiers and doctors should not be prosecuted for following orders, that victors imposing justice on the defeated was illegitimate. Every argument had been addressed and rejected at trial. Every justification had been proven legally worthless. Yet the families persisted, revealing how deeply Nazi ideology had penetrated German society. American occupation authorities responded to these clemency petitions with detailed refutations. They published summaries of evidence against each convicted doctor. They explained why following orders did not constitute defense. They described the suffering inflicted on victims, and they made clear that sentences would be carried out as imposed. No appeals based on German legal traditions would be entertained. No clemency based on national service would be granted. American justice had reached its conclusion, and that conclusion was final. By September 1947, Germany was forced to confront an uncomfortable truth. American justice operated with a speed, efficiency, and finality that German legal systems had never achieved. American courts had proven crimes that Germans had convinced themselves were unprovable. American prosecutors had held doctors accountable when German institutions had failed to do so. The convictions of 16 Nazi doctors in a single day had demonstrated American legal capacity, shattered German assumptions about victors' justice, and established that accountability for medical war crimes would be swift, certain, and irreversible. Germany had been humbled not by military defeat alone, but by the demonstration that American systems, American values, and American determination could document, prosecute, and punish crimes that Nazi Germany had committed with bureaucratic precision, but assumed would remain unpunished. The execution of the 7 death sentences occurred on June 2, 1948, at Landsberg Prison in Bavaria. American military authorities carried out the hangings with the same efficiency that had characterized the entire trial process. No delays, no stays of execution, no last-minute clemency. The condemned Nazi doctors who had believed their medical credentials would ultimately protect them walked to the gallows knowing that American justice had proven faster, more thorough and more final than anything Nazi Germany had achieved. Karl Brandt, who had been Hitler's personal physician, who had authorized the murder of over 70,000 disabled Germans, who had coordinated medical experiments across the concentration camp system, was hanged at 10:08 a.m. His last words were reported as a continued justification: "I served Germany." The American executioner made no response. Service to a criminal regime did not constitute defense under American law, and Brandt's execution demonstrated that principle with absolute finality. The hanging sent shockwaves through German medical institutions. Hundreds of doctors who had participated in Nazi medical programs but had not been prosecuted at Nuremberg suddenly understood that their careers were over, that their reputations were destroyed, that the international medical community would never accept them. Many fled to South America or disappeared into remote German villages. Some committed suicide. Others attempted to rebuild medical careers under false names. But the message was clear. American justice had reached into the highest levels of German medicine and imposed accountability that would last generations. The Nuremberg Code, formulated by American military lawyers and medical ethicists based on the Doctors Trial evidence, became the foundation of modern medical research ethics. Its 10 principles established standards that had been obvious to ethical physicians for centuries, but had never been codified in international law. The first principle was absolute. The voluntary consent of the human subject is absolutely essential. This single sentence invalidated every justification the Nazi doctors had offered. No military necessity could override consent. No racial ideology could exempt researchers from ethical obligations. No claim of superior knowledge could eliminate the requirement that patients understand and agree to procedures. The Nuremberg Code transformed medical research worldwide. Before Nuremberg, human experimentation was regulated inconsistently, if at all. After Nuremberg, every legitimate medical institution adopted consent protocols, ethical review boards, and oversight procedures. The American Medical Association revised its ethical guidelines. The World Medical Association created the Declaration of Helsinki based on Nuremberg principles. Medical schools worldwide began teaching research ethics as a core subject. The impact extended beyond medicine. The Nuremberg Doctors Trial established legal precedents that influenced human rights law, international criminal law, and accountability mechanisms for decades. The principle that individuals could be held criminally responsible for following illegal orders became foundational to international justice. The concept that certain acts constituted crimes against humanity, regardless of national laws, reshaped how the international community addressed atrocities. The documentation standards established at Nuremberg became models for future war crimes tribunals. For Nazi Germany, the 16 convictions in a single day represented a final humiliation. The Third Reich had prided itself on scientific advancement, medical expertise, and bureaucratic efficiency. American justice had used Nazi Germany's own methods against it. German documentation had provided evidence. German organizational systems had preserved records. German medical research had exposed criminal intent. The Nazis had assumed their thoroughness would impress the world. Instead, their thoroughness had created an unbreakable chain of evidence that American prosecutors used to achieve unprecedented accountability. The speed of the convictions particularly devastated German assumptions about justice. Nazi ideology had taught Germans that power determined outcomes, that the strong imposed their will on the weak, that victory erased responsibility for methods. American justice demonstrated that power could enforce rules rather than override them, that strength could be channeled through legal systems rather than expressed through force, that victory created opportunity for accountability rather than license for revenge. These lessons were hard for Germans to absorb. But American occupation authorities enforced them relentlessly through legal reforms, educational programs, and cultural transformation. The contrast between Nazi medical crimes and American medical ethics became a central theme in post-war German re-education. American occupation authorities brought German medical students to visit former concentration camp medical facilities. They required German doctors to attend lectures on research ethics delivered by American and British physicians. They distributed translated copies of the Nuremberg trial transcripts to every German medical school. The message was consistent and unrelenting. German medicine had been corrupted by Nazi ideology. American and Allied medicine had maintained ethical standards even during war, and German medical institutions would be rebuilt on international ethical principles or would remain under occupation control indefinitely. The psychological impact on ordinary Germans was profound. Many had convinced themselves that Nazi crimes were exaggerated or that American accusations were propaganda. The Nuremberg Doctors Trial destroyed these illusions. The evidence was too detailed, the documentation too extensive, the testimonies too consistent. Germans could not dismiss American justice as victors' revenge when verdicts were based on German medical records, when defendants were convicted using their own documentation, when sentences reflected degrees of individual culpability rather than collective punishment. The trial forced Germany to confront the reality that its medical profession had been criminalized, that doctors had become murderers, that healing had been replaced with harm on an industrial scale. By the 1950s, the impact of the Nuremberg convictions had spread globally. Medical researchers in the United States, Europe, and Asia adopted consent protocols and ethical review processes. The Tuskegee syphilis study, which had operated unethically since 1932, began facing criticism based on Nuremberg standards and would eventually be shut down in 1972 when revelations triggered public outrage informed by Nuremberg principles. Pharmaceutical companies revised their clinical trial procedures to ensure informed consent. Government health agencies established human subject protection regulations. The medical research enterprise worldwide transformed because 16 Nazi doctors had been convicted in a single day by American military tribunals that operated with unprecedented speed and efficiency. The legacy of August 20, 1947, extends to the present day. Every institutional review board that evaluates research ethics traces its authority to Nuremberg principles. Every consent form that patients sign before participating in medical research reflects standards established at the doctor's trial. Every medical student who learns about research ethics studies cases from Nuremberg. The 16 convictions achieved in a single day by American military justice created a framework for medical ethics that has prevented countless abuses and protected millions of patients. Over the past 75 years, Nazi Germany had been humbled not just by military defeat but by the demonstration that American systems could achieve justice with a speed, thoroughness, and finality that authoritarian regimes could never match. The Nazis had believed that complexity would protect them, that destroyed Germany would lack accountability mechanisms, that victors would move on rather than document crimes. They were wrong on every count. American prosecutors had turned Nazi documentation against perpetrators. American legal systems had processed complex cases with industrial efficiency. American occupation authorities had imposed accountability that reshaped German society. The 16 convictions delivered in a single day in August 1947 proved that American justice, when applied with determination and resources, could hold even the most powerful criminals accountable, establish precedents that would last generations, and demonstrate that the rule of law was stronger than any ideology of power. This was not revenge. This was not victor's justice. This was American institutional capacity applied to accountability, and its impact continues to shape medical ethics, international law, and human rights protection worldwide.